We are here on 175th webinar, which is another milestone. Until now, we have completed 174 webinars over last 3.5 years, with over 110,000 participants registered and attended. More than 225 panelists, including judges, member of parliament, IAS, IPS, IRS officers, regulator from MCA, CCI, IBBI, SEBI, former regulators, industry leaders, corporate professionals, and practicing professionals have shared their knowledge through this platform. And I'm so happy that this journey, which we are continuing since last 3.5 years, it is continuing. And we promise that it will continue in future also. So sharing knowledge and giving something what you have learned is our age-old process of sharing knowledge. And we want to do this every time, every Friday, on every new topic. Today we have selected this topic, fast-track merger. It's a very interesting concept which is introduced by New Companies Act, and the process designed to simplify and expedite the merger procedure, allowing the quicker approval without court intervention, because we have seen in the court, it is presumed that court is taking too much time. So that's why we are having this type of quicker approval without court intervention. This process provides a specific class of companies. All companies are not allowed, but a specific class of company with an alternative method of meeting or process of merging. As per the Companies Act, a fast-track merger can be done between two or more startup companies, one or more startup company with one or more small companies. So two or more small companies and holding company and wholly owned subsidiary companies. So you can understand the startup company can merge, the small company can merge, and the holding and subsidiary company can merge. And these things can be play a small company with startup with a startup. All these things can take place. So this is the criteria. Other than this, you have to go to NCLT and you have to take approval as per the NCLT process, which is a complete merger process. Now, today we want to discuss key area of discussion, that is the regulatory framework of fast-track merger, that what is the regulator law, procedure, and other thing. Procedure for fast-track merger. So first law, and then what is the process, then documentation, reporting requirement, regulatory approval and compliances, issues and challenges faced during the process, and tax aspects in fast-track merger and stamp duty aspects of the fast-track merger. Now, if you see this, according to data available on MCA website, a total of 403 applications were received and 350 applications were disposed of during the period of November 1st to 2021 to October 31st, 2022. So you can understand that this power rests with the regional director. So all the regional director combined in India during this period, they have approved for 315 fast-track merger. So you can understand the speed is fast, things are simplified, and other things are there. But the question is it correct? The process is fast and simplified, or it has some issues? So today we want to discuss all these points, not only the process. So as a layman, you want to start your small company merger. So you should know what is the process, what are the requirements, how to do it, what are the tax issue, what are the stamp duty issue. But simultaneously, we will discuss this also in the entire journey, what problems the corporates are facing, professionals are facing, and how to overcome this. So for this, we have requested a very interesting panel and we have invited two RD of Delhi and the Bombay, who are receiving the maximum cases of this. And then we have requested the regional director of joint director from MCA in Bombay. So I extend a very warm welcome to my all learned speakers. First, Mr. Santosh Kumar, who is an Indian Corporate Law Service officer currently serving as regional director of the Western Wing, Western region in the Ministry of Corporate Affairs. He is one of the very dynamic and very knowledgeable professional, and he has worked in various departments, various positions he has undertaken, and his vast experience and knowledge will definitely help today and the way he is helping the entire corporate world. I welcome Santoshji. He is joining. He is in a meeting. He will join shortly. Then we have Mr. Vinod Sharma. He is an Indian Corporate Law Service officer, currently serving as a regional director of Northern Region at the Ministry of Corporate Affairs, MCA. Vinod Sharma ji is also from the grassroots, from the beginning. He is in the Ministry of Corporate Affairs, and he has understood the entire nitty-gritty of various corporate work, including he was official liquidator also, he was ROC also, he was now regional director. So he has undergone so many experience during this period. So definitely his experience will be helpful to us. Then we have Miss Yogini Dinkar Chauhan. She is ICLS officer, currently serving as a joint director, regional director, Western Region, MCA. And Madam is looking after the fast track merger and other things also. But for today's topics point of view, she is the main in charge in the Western Region, who handles and who approves and who suggests changes relating to all cases. I welcome Yogini Madam for today's program. And friends, these three persons, they are the managing the maximum cases of fast track merger in India. They are the person who is receiving cases, and they are the person who is approving cases. So these three person will definitely tell us that what are the issues, why the issues are not complete, what types of things people are confused, what types of things are coming, how corporate should do certain things, so the process can be faster. So the purpose of the program is that we can take the maximum viewpoint and the advantage of their knowledge and their advice to the corporate world. Friends, then we have Mr. Manoj Kumar, partner head M&A and transaction advisory from corporate professional. He has handled more than 300 plus 400 to 300 mergers and various corporate advisory, more than 100 listed company merger he has done, and various fast track merger he has undergone. So you can understand his vast experience will also helpful, and Manoj's presentation will give the corporate world that they can follow the process and they can understand this. So welcome, Manoj. Then we have Mr. Suman Kumar Jha. He is a corporate lawyer. He is working with corporate professional earlier. Now he is an independent corporate lawyer, and he is associated with corporate professional. And he is the backbone of Manoj when mergers are taking place. And he is helping the M&A division and especially Manoj team. So I welcome all 5 professionals for this, and I welcome all my attendee, those who have come in a large number to understand the importance of this program. So they will definitely get something new. Friends, before going to this, I have to just make one announcement. As our journey of knowledge sharing is going on, so our next webinar is on 176th webinar on 14 June at 4 o'clock will be on importance of ESG integration strategy targeting going net zero. This is our plan. After LOD or BRS are format of SEBI. Every listed company with the staggered basis, they have to follow this. So the ESG is not a something different. It is a part of the all listed companies corporate work. It is a part of their system and they have to follow. So friends, without taking much time, I will just tell you the program structure. First, Manoj Kumar will give a presentation, and in the presentation, he'll give the procedure. He will give the how to do this, what are the main points, the tax aspects, stamp duty aspects, and various other documentation, and then some case study he will share. And after that, I will request Mr. Santosh Kumar, Vinod Sharma, and Yogini Madam to discuss about the regulatory aspects. And the most important thing in their discussion that will be there, that they will tell us that what are the problems corporates are facing and why, and what corporates should do so this merger process and everything can take faster route, and people should not confuse. What are the issues where corporate word is confused? What are the issues where professional are getting some different interpretation? So all these issues they will tell us. Then we will take Suman Kumar. He will tell practical aspects which fast track merger is taking place, and then we will have a question answer. So anybody has any question, you please write to us. Now, without me taking much time, I'll request Manoj to share a presentation.
Good afternoon, friends. So today's topic is very, very important and critical topic. In the corporate world, fast track merger or merger and amalgamation is always a very typical transaction which happens over a period once in a lifetime, or even sometimes twice or thrice in a lifetime. So, and it is always very complicated and time-consuming process. So nitty-gritties of these are very important for all the professionals working on the same. Friends, as we all are aware that the New Companies Act, when it came in 2013, it brought certain new concepts, such as the concept of small company, dormant company, then the concept of fast track merger, which we are discussing today, the merger of cross-border merger of Indian company and companies overseas. All those new concepts brought to bring ease of doing business for the corporate world. So the fast track merger, which we are talking today or we are discussing today, is one of such important new concept which has come in 2013. In 2013's Companies Act, there was also a big change when the merger matters or merger or corporate restructuring matters were shifted from High Court to NCLT. So it brought down the timeline also, and the object was to lower the burden of the judiciary and create a specialized judicial body, quasi-judicial body, which can handle the merger amalgamation or corporate restructuring. Similar to the same, in further liberalization or further simplification of the process, it was also decided that most of the companies which are small in size or which are holding and subsidiary, where the arrangements are not so complicated and the public interest is not getting hampered, should be shifted to the officer of the MCA, which is the regional director, and so that the burden of even NCLT get reduced drastically and the process could be very fast tracked. Considering this, the concept of fast track merger is getting relevance, and today we are discussing the same in a detailed manner. So today, me as well as my colleague Suman would discuss the entire gamut of the process of the fast track merger. What are the legal implications? What are the legal position in India? What is the process? What is the other relevant laws which need to be taken care of, like income tax law, accounting treatment, stamp duty related things? All those things would also be discussed. And then we will discuss certain point of discussion which are very much critical. We will also discuss a few landmark judgments relating to the fast track merger, and then we will have a detailed question answer session. So to start with, I think if we see the concept of fast track merger came as part of the chapter 10 of the J.J. Irani Committee report of 2005, where it was decided that M&A is very important and it should be streamlined and fast tracked so that the corporate world get benefited. Then certain special class of companies should be given a fast track mode and should not be transferred to the normal merger route, which is through the NCLT. So now I think I would hand over the procedural part, starting point, to my colleague Suman. He will run through the basic concepts and the terminologies which are important for considering the amalgamation and merger or demerger of fast track companies. So over to Suman from here.
Thank you, sir. Thank you, Pavan, sir, for this opportunity. Thank you. So basically, if you will see the legal framework of fast track merger, then there are four main applicable parent law. That is Companies Act 2013, then Income Tax Act 1961, SEBI LODR in case of listed entity, and stamp duty aspect. So these are the four major law. So when you are planning for fast track merger, there are some prerequisite for it. Like first, the company should be a small company. Second, the company should be a startup company. Third, there should be holding and wholly owned subsidiary relationships should subsist. Then the most important part is that the company should be able to file declaration of solvency. Declaration of solvency, the concept in which company will declare that we will able to dispose all the debt, means the net worth of the company should be positive. Next slide, please. So the definition, if we will see the definition part, then section 2 subsection 85 defines small company, then section 2 subsection 87 defines subsidiary company, then section 2 subsection 46 define holding company, and then DPIT came with the concept of a startup company. So why these are the important terminology, because these will play major role in fast track merger. So if we will see the concept of a small company, it defines that the paid up share capital of which does not exceed 50 lakhs rupees or such higher amount as may be prescribed, and turnover should not be exceeded by more than 2 crores or such higher amount as may be prescribed. However, recently MCA came with the circular that paid up capital, share capital may go up to 4 crore and turnover may go up to 40 crore. If the company will qualify such condition, then it will be treated as small company. Then there are some exclusion in the definition of a small company, that the holding or subsidiary company, company registered under section 8, company governed by a special act, like some companies like Central Warehousing Rail Corporation. So these are the company incorporated under a special act. So it will not covered in the definition of a small company. So subsidiary company means in relation to a holding company, means a company in which the holding company controls the composition of board of directors and exercise or controls over and one half of the voting powers along with its subsidiary. So like first condition should be satisfied or second condition should be satisfied. If the condition, any of the condition will be satisfied, it will be treated as holding company. Then wholly owned subsidiary means, in case of wholly owned subsidiary company means 100% equity share are owned by another company. Then in that case, it will be treated as holding company. So as I told you earlier that, yeah, a startup company. So a startup company must be recognized by Department of Promotion of Industry and Central Internal Trade. So when the concept of startup company came, then DPIT came with the modification that yes, small startup company will be also considered for fast track merger. The criteria is like incorporated as private limited company, partnership firm or LLP, operational for less than 10 years from incorporation or registration. Turnover should not be exceeded 100 crores in any financial year since incorporation. Engage in innovation, deployment, development, or commercialization of any new process, products, or service driven by technology or intellectual property. So these will fall under the startup company definition. I think we have already. So yes. So during the process of fast track merger, the most important part is declaration of solvency. You may say that this is the document which is most important. First, when you are planning for fast track merger, you have to check that whether company is able to file declaration of solvency or not. So first, the format has been prescribed by under Companies Act. So declaration of solvency means the test of solvency should be checked on, like the company is capable of meeting its liability as and when they fall due first. Then the company will not be rendered insolvent within a period of 1 year from the date of making this declaration. But while we are planning this kind of merger, first we see that whether the net worth of the company is positive or not. If the net worth of the company is positive, it means we presume that yes, the company will be able to dispose the declaration of solvency. So there is format prescribed under NCLT rule, so that there should be a statement of asset and liability, and the most important part, the book value of the statement of asset and liability will be there. But after book value, there will be one column categorized as realizable value. So the realizable value of the asset should be also there. The statement of asset and liability should be on the latest date of making this declaration. Generally, a period or not more than 6 months is advisable, but this should be on the basis of audited financials. And when auditor of the company will give the declaration of solvency to the board, then 2 directors must certify this declaration of solvency when we are planning to file the fast track merger. So these are the process. Like first, we need to prepare the scheme of arrangement. If in case of like wholly owned subsidiary, there is no valuation, but if to a small company or on a different company, private company, which will fulfill the definition of a small company, then you need to get the valuation report also. So first, planning on scheme and valuation will be done. Then you have to prepare form CA10, which is most important form, like declaration of solvency, as we have told. Then there will be a board meeting to approve the draft scheme of arrangement, to approve the declaration of solvency, to approve the share entitlement report in case of demerger and share exchange ratio report in case of merger. Then to empower the director or company secretary to execute all the necessary documents. Then we have to file the give the notice in the form of CA9 to ROC, official liquidator, for their comments and observation, and they have to give their comments and observation within 30 days. The most important part is that in law only it provides only ROC and official liquidator, but practically when you will file CA11 on later stage, then they will also ask that whether you have given intimation to income tax department or not. So it is advisable that when you are planning to file CA9, you must intimate income tax department also at that level. So after that, next step is filing of declaration of solvency. You have to file the declaration of solvency with ROC. Then in fast track merger, you have to suo motu convene the meeting. You have to convene the meeting, get the approval from 90% well in terms of value from shareholder and creditors. Although there is provision of consent affidavit of creditors, but in case of shareholders, you have to convene the meeting, and the shareholders having 90% value of shares must be approved this kind of a scheme of arrangement. Then it will be considered as approved. Next slide, please. Then shareholders and creditors will approve the scheme with requisite majority. Then once shareholder and creditors will approve the scheme of arrangement, then within 7 days, you have to file CA11. CA11 scheme and proceeding of minutes will be there. Then you have to also give the proof along with CA11 that you have given the intimation to income tax department, registrar of company, official liquidator, and you have to pay fee as prescribed under MCA rules in RC1. Then you have to give the intimation to registrar of company in the form of CA11 for final observation. So once you will file the CA11 before RD, ROC, and again OL income tax department, then they have to respond within 30 days to regional director, office of the regional director. The most important part, that CA11 will be filed only before the RD of transferee company. If there are one transfer and one transferee company, transfer company having different jurisdiction and transferor company having different jurisdiction, then in such case the CA11 will be filed before the RD of transferee company only. Then RD will confirm the order after satisfactory observation of official liquidator, registrar of company and income tax department. Then once you will get the order, then you have to file INC 28 to make the order effective. So I think procedure part completed. Should I? Yes.
So thank you, Suman. Now I will take up the other laws applicable on this scheme of arrangements. So it is also important to note that what are the other legal implications rather besides the procedural aspect. So if we talk about any scheme of amalgamation or demerger or merger, it has to satisfy the accounting treatment, accounting standards prescribed by Ministry of Corporate Affairs as part of the rules under Section 133. So the amalgamation or demerger, whether it is fast track or otherwise, has to comply with the Ind AS or AS as may be applicable. So for all normal companies, the small companies, and the companies which are other than the listed companies or certain class of companies, accounting standards, old accounting standard 14 would be applicable. All for listed companies and other large size companies, Ind AS 103 would be applicable for all kind of mergers and amalgamations. So accounting standard 14 clearly talks about two type of methods. One is pooling of interest method, where all the assets and liability of a company which is getting merged should be line by line consolidated with the other company which is acquiring the company, which is getting the company transfer, which is called the transferee company. Similarly, in case the two companies are not controlled by the same group of persons, then under AS 14, there is another method which is the purchase method of accounting, and there each assets and liability may be brought to their fair value and acquired by the company which is the transferee company. So in case the company is listed company or a large size company where Ind AS is applicable, then the method of accounting, which is pooling of interest method or purchase method, is not optional but mandatory. So as per Ind AS 103, all companies which are under the common control must follow the pooling of interest method. Rest of the companies where there is no common control, then the purchase method is mandatorily applicable. So we have to understand, wherever we are planning for merger or making a scheme of arrangement, we must keep accounting treatment proper in the scheme, and the same accounting treatment must be certified or confirmed by the statutory order of auditor of all the companies involved in the scheme of amalgamation. If we talk, another important law which is applicable for any kind of merger or amalgamation is the income tax law. Generally, it is understood that the scheme of amalgamations are tax neutral. There is no tax implication while we approve the scheme. However, the same shall be applicable, or exemptions shall be availed by the companies only if the definition of amalgamation as prescribed under the Income Tax Act are getting fulfilled. So we have to understand the definition of amalgamation as prescribed under 2(1)(b) of Income Tax Act, which is very critical, and there cannot be partial implementation of this definition. Otherwise, the exemption available under Section 47 of the income tax would not be available to the scheme. So generally, most of the scheme of amalgamation, including the fast track amalgamations, get fully complied with this definition of amalgamation. The amalgamation definition is the clear definition of amalgamation is not prescribed under Companies Act, but the definition of under income tax is very much similar, and it says that all assets and liability of the transferor company must be consolidated, must be acquired by the transferee company, and the shareholders of transferor company should get the shares in consideration of the company getting merged. So this definition is generally fulfilled in all of the schemes. In case we are fulfilling the definition of amalgamation as prescribed under the Companies Act, Income Tax Act, then the Section 47 clearly says that nothing contained in Section 45 of the income tax relating to the capital gain should apply to the amalgamated company or amalgamating company or its shareholder. So both are getting fully exempted. This transaction of amalgamation would not be considered as transfer. So there will be a pass through and no tax liability will occur while the amalgamation happens. Again, if there is a carry forward of losses, if there are accumulated losses in the books of the transferred company, and those need to be transferred to the books of the transferee company as part of the scheme of amalgamation or arrangement, then the conditionalities prescribed under Section 72A of income tax must be taken care of, must be complied with. So Section 72A is applicable only to the merger amalgamation of company having industrial undertaking or hotel. Another section is banking company as referred in Section 5 of Banking Regulation Act, or one or more public sector company. Only these three class of companies would get the benefit of 72A, where all accumulated losses or unabsorbed depreciation of the transferred company can be transferred to the transferee company as part of the scheme. It is very important part because sometimes the accumulated losses and unabsorbed depreciation size is much higher, which can be a great benefit to the transferring company in the post amalgamated scenario. There are certain further, we have to fulfill 2-3 other conditions. One condition is that the accumulated, there has been the business for which the accumulated losses have occurred should continue for 3 or more years, and at least 3/4 of the value of the fixed asset, book value of the fixed asset of the transferred company should continue with the transferee company, amalgamated company. Another condition is that the amalgamated company should continue with the business or the assets of the company for at least 5 years, and at least 3/4 of the book value of the fixed asset of the amalgamating company would, as acquired part of the scheme, should continue. The business should continue for a minimum period of 5 years. If these conditions are getting fulfilled, then the exemption, then the carry forward or losses or unabsorbed depreciation would be allowed. Otherwise, all the in case there is a transfer of assets or discontinuation of business, then the losses, benefit of losses taken would get reversed. Another aspect is the demerger. So one query is always in the mind of the many people, that the provisions of fast track, whether it is applicable to demerger. So yes, the provisions of Section 233 of the Companies Act, which talks about the fast track merger or merger of certain special class of company, it is not only about the merger, but all kind of scheme of arrangements as prescribed under Section 232 of the Companies Act. So it refers back in the subsection 12 of the Section 233 clearly refers back to 232 and covers all kind of scheme of arrangement. So demerger would also be part of, can be applied under Section 233 to the regional directors concerned. So here comes the provision of income tax. Income tax specifically defines the demerger, which is provided under Section 119AA, 219AA, and 219AA is generally very much similar to the amalgamation, but it talks about certain undertakings. So all properties, liabilities of the undertaking should be transferred. It should not be partial. It should not be asset sale or certain assets are getting transferred as a slump. So it has to be transferred as a going concern, and the transfer should happen at carrying book value in the books of the demerged entity company. Otherwise, it will not be considered to be a demerger. Then obviously it also says that it does not include transfer of individual assets or liabilities or a combination, but it should be a business undertaking or business activity which should be transferred from one company to another to fulfill the definition of demerger. If the definition of demerger is getting fulfilled, then Section 47 clearly gives exemption from the capital gain liability at the transfer of such assets as part of the demerger scheme. Again, if we talk about the transfer or carry forward of past losses or unabsorbed depreciation relating to the division which is getting transferred as part of the scheme of demerger, the 72A provides certain conditionalities, which is very much similar to the merger. And if those conditionalities are getting fulfilled, then the past losses or unabsorbed depreciation of the division which is getting transferred as part of the demerger would get transferred and which would be available to the resulting company which has acquired the business. Now, if we consider a listed company, whether the fast track route is available or not, so here there is a difference of opinion, but the law is very much similar, very much clear that Section 233 is not talking about listed or unlisted. It is simply saying if the any of the three conditions are getting fulfilled, then you can avail the benefit of 233. So first condition is the companies are either both the companies are small companies, or both the companies are a startup company, or one is a startup and another is a small company. And another one option is that there is a holding company and wholly owned subsidiary. So if the amalgamation proposed is between holding company and wholly owned subsidiary, irrespective of the nature that it is a listed company, it can be merged or amalgamated as part of the under Section 233. Here comes the provision of SEBI LODR. SEBI says that in case of amalgamation or merger of holding company and wholly owned subsidiary, there is a full exemption from the pre-approval from the stock exchange SEBI, pre-clearance from stock exchange SEBI, which is applicable to all kind of amalgamation or a scheme of arrangements involving a listed company. So if we are planning to have fast track merger of holding company and wholly owned subsidiary, where the holding company is a listed company, we can certainly avail the benefit of this exemption from SEBI and stock exchange pre-clearances. And hence, if we are fulfilling all other conditionalities, then this is a possibility. Now comes another very important part, which is the costly affair for any scheme of amalgamation, that is the applicability of stamp duty. So in all merger amalgamation transactions, stamp duty is very critical, and we every company should consider while making the scheme. So generally, it is now well settled position that a scheme of amalgamation or demerger, as approved by court, high courts or NCLT or even RD, would be considered a scheme conveyance deed, and hence stamp duty would be applicable because it is a well settled position at Supreme Court level. So nobody is challenging. However, there are a lot of confusion because different states have different laws relating to merger amalgamation. Certain states have a specific law which prescribes the rate of duty for merger amalgamation schemes, but there are other states which have not provided any specific rate, and hence the normal rate of conveyance may be applicable. Like in case of Delhi NCR, the Delhi Stamp Act as amended for the Delhi has no provision relating to merger or amalgamation or demerger. But in the famous judgment of Delhi Towers, it was held that the scheme of amalgamation or order of High Court and NCLT would be considered to be a conveyance deed, and the duty at the rate of 3% of the consideration amount should be applicable. So this is going on. Different states have different rate of stamp duty for scheme of arrangement, which will also be applicable to scheme of merger amalgamation approved under Section 233. So, for example, in Andhra, there is a rate of duty of 2% on the fair market value of the properties being transferred as part of the scheme. The Chandigarh has prescribed a special rate that 7.5% of the market value of immovable property getting transferred. Sorry, I am talking about Chhattisgarh, or 0.7% of aggregate market value of shares being issued as part of the consideration, whichever is higher, would be applicable as stamp duty. Madhya Pradesh has different rate, which is 5% of the fair value of immovable property, or 0.5% of aggregate value of shares being issued, whichever is higher. Similarly, if we talk about Gujarat, the rate of duty is 1% of aggregate value of market value of shares issued or allotted, or face value of shares, whichever is higher, and consideration paid as part of the amalgamation, or 1% of the fair value of immovable property situated in the state of Gujarat. whichever is higher, maximum of 25 crores. So similarly, Kerala has different rate of duties, and uh, so why we have to consider this. Maharashtra has different rate of duties. West Bengal has quite a different rate and method of calculating the duty. So while the rate of duties may be different, but we have to keep in mind that all merger amalgamation transactions is subject to duty, and the duty may be charged by both the states, all the states involved in the scheme of amalgamation, where if the companies involved in the scheme of amalgamation have different registered different states where the registered office is there or the immovable property are situated. So while making the scheme, we must plan accordingly, and we should factor in the cost involved while making the calculating the stamp duty liability. If we as the loosely we all say section 233 is a fast track merger, so we should understand how it is fast tracked and how fast it can be. So if we consider the comparative timeline of the two kind of scheme of amalgamation or demerger, if we go under section 233, the step would be first make a scheme of amalgamation or demerger, and also get valuation done if required, and then place it before the board of director, then file it with get the declaration of solvency prepared and approved by the board of directors, and get it not affidavit signed by two directors, and file it with ROC and OL, and wait for 30 days. The law says that we have to wait for 30 days for their comments. If there is a comment, there are certain comments coming from ROC or OL on the draft scheme, then those should be incorporated in the scheme, and then the same said scheme should be placed before shareholders and creditors for their approval. As soon as the approval of shareholders and creditors with the sufficient majority, which Suman has already told, that is 90% of the value of each class of shareholders and creditors. So if there are equity shareholders and preference shareholders, we need 90% value of each of those to approve the scheme. Similarly, if there are secured creditor and unsecured creditor, or even public deposit or some other kind of class of creditor, we should take the approval from that class of each class of creditors with 90% of majorities. So the approval of shareholders would come generally in the form of AGM, EGM, whereas the approval of creditors may be in the form of in a meeting or through written consent from those creditors. After getting the sufficient consent from creditors as well as member, company would file the CA 11, which is the confirmation request from RD, within 7 days from the last date of approval. And from there, the consent, the process before the regional director would start. So the same notice, the copy of the final scheme and other paper would also be served served to other regulators like ROC, official liquidator, income tax. And if there is any other sectoral regulator, those should be given the notice, and they should give their confirmation or comment to regional director within 30 days. Post that, the regional director might have a representation meeting with the member with the official of the companies involved or the representative lawyers of the company, and based on that discussion, the regional director may pass the order confirming the scheme of amalgamation. So generally this process would take 4.5 months. So it is a very crisp and timeline prescribed method. Whereas if we go by the normal NCLT route, generally it would take 8-9 months, because the approval here in this case, post approval of the board of director, application is filed with NCLT seeking directions to call the meeting of creditors and shareholders. Here the meeting is held under the supervision of the court directed chairman or alternate chairman, and generally the timeline would be much higher than normal AGM, EGM. So it will be 2 months or 2.5 months. Post their confirmation, the approval of the scheme by the shareholders and creditors, and consent, the comment of the chairperson would be filed with the NCLT concern, and then the company should file the second motion petition, which is the approval of the scheme petition with the NCLT. the NCLT directs the directs the notice to all the regulators like ROC, RD, official liquidator, income tax, sectoral regulator, etc. And post their consent, the final approval comes. So generally, which is practical thing, that 8 to 9 months is being taken by in most of the cases, unless we are able to get the no objection of shareholders and creditors for this scheme of amalgamation. So NCLT route generally takes much higher than normal time. In case a listed company is involved, then the scheme would take further 4 or 5 months, 3 4 months. And similarly, similar timeline may also happen to companies which are regulated by some other regulator like RBI and NBFC companies. So the timeline is almost double in all such cases. Hence, fast track merger is always better if you are eligible and you can go ahead with the scheme. We discuss a few famous cases or good cases which can be helpful in planning for all the concerns. So these are cases relating to fast track merger or section 233 mergers. One thing comes into the mind, as we have discussed earlier also, whether a scheme involving a listed company can be approved under section 233. So here the answer is yes, it is possible. There are two examples to us. One of the cases relating to Optimus Infracom, which is a listed company, and its two wholly owned subsidiary got merged into it. We carried this transaction ourselves, so we know, we are privy to this. The other one is Quest Corp Limited, which is also a listed company, and its wholly owned subsidiary, its 4 wholly owned subsidiaries got merged into it. So that merger was also happened, and it is a listed company. So we can clearly say that this is a possibility. However, we have to see the challenges relating to getting the consent from the 90% in value of the shareholders. We were able to get the consent of 90% or more because the number of shareholders were limited, and or in such cases where there are 2 or 3 major shareholders besides the promoter group, which is holding, let's say, more than 15% shares, and they give their consent in the AGM or EGM, and then it will be approved by more than 90% of the shareholders. If that happens, then the matter can go in under the fast track route under 233. Another important aspect is whether the approval of shareholders by 90% or more of the value is relating to the entire value or with respect to the persons present and voting. So here there is a difference. The law is very much clear that the approval should happen at least 90% of the value of the shareholders. However, in case of Fort Gloucester Electricals and JC Chemicals Limited, the RD Kolkata has approved a scheme with only 43% of value of the shareholders present. He considered that the approval by entire 43% shareholders who were present and voting had approved it. So it is 100% approval and not the proportionate approval which were present and voting, which were from the entire share capital of the company. So it may be a deviation from the legal position, but this is the position, and this has been confirmed in some of the cases where the matter went to NCLT in post rejection by the regional directors. So we will discuss those cases also. So in case of IDFC Limited versus regional director, the matter was first filed under 233 before the regional director, but the regional director had not approved the scheme, considering the fact that only 52.09% of the shareholders approved the scheme. Despite the fact that in the e-voting, 99.9971% of the shareholders who voted in favor of the scheme. However, the regional director fit it proper to not to approve it because the loss is 90% of the value of the shareholders of the company. So it is about the 100% share capital, not the present and voting concept. So regional director rejected the scheme. However, the matter was brought to the NCLT's notice, and NCLT considered the fact that the scheme was not detrimental to the interest of the shareholders, and all statutory approvals or compliances have been made. So the tribunal sanctioned the scheme under 233 subsection 6, where the tribunal has power to approve or reject the scheme which is not considered fit by the regional director. Similar to the above case, there were a few cases where the RD has rejected the scheme, considering it is not fit for, not in the interest of the public or the creditor, and also considered that the valuation report was not provided by the company along with the filing with the scheme. So the matter went to the regional director and sorry, NCLT, and NCLT discussed in detail what is public interest and held that simple negative to one or more of the creditors may not be considered to be against the public interest, not in public interest, or simply not giving the scheme valuation report would not be considered to be detrimental to the public interest or not fair and reasonable, and hence it is not, as the valuation report is not a precondition for a scheme of arrangement under 233. So it approved the scheme which was rejected. So these are a few important cases where deviations have been found, and it was found that NCLT has considered those schemes, those schemes which may not be fully in line with section 233, and there is legally there is no specific provision under section 233 for any applicant to go directly and in appeal at NCLT level. However, we have seen that NCLT considers all such schemes which are not approved by regional director. So we will obviously discuss with the Yogini madam and regional directors who will join then. So what is their take on this kind of things? Thank you very much for my
Okay. Thank you, Manoj. Thank you very much. Thank you, Suman. Now, what we can do, we have received more than 20 questions, and we have already 20 questions we received yesterday. So there are 40 questions. So Manoj, first I will take the view of Yogini madam. Then as soon as Mr. Sharma and Mr. Kumar joined, then we'll take the. Madam, now Manoj has given the presentation on the legal and technical part, and as a professional. But now you are handling these cases day and night.
Yes.
And you are facing various type of things where there is a rejection. Then from the professional side, he may say, I have submitted everything, regional director has rejected. So your substance which you are doing and which you are accepting and rejecting, okay, on some logical basis, on some legal ground, some interpretational issue, which you are upholding what the law is saying. So I just want to take your view for the benefit of everybody. So over to you. Then we'll take question answer. Then you can give answer.
Yes. Good evening, everyone. It is a
Good evening.
nice session. It's a nice session and a great PPT. And I also got to know the other tax, the angle of tax and everything, which we are limited to what Companies Act says and whether we are given complete papers or not. We are not bothered about what happens to the income tax thing and all that. It was a very enriching session. And congratulations for the 175th webinar also, Pavanji. It's a great effort. And it is difficult to, and it's a good this thing for youngsters also, so that they come to know, even if you practice or don't in such areas, it's always good to know and add to your knowledge. So it's a very good initiative, and keep it up. So
Thank you.
I have been doing fast track mergers for the Western region from the last 2 years, and almost 200 cases have passed through my hands. And sir has been very cooperative, and he has a very open approach basically. Like if you can approve it, just approve it. The basic things are there. We generally try and approve the cases. So, and with this the new circular coming in, wherein 60 days is our timeline. So it has actually, like even I thought it was very difficult because people don't give documents even after 4-5 reminders. There is no one we can find like what are the documents and everything, but it becomes very easy when there's a 60-day timeline. Stakeholders are also having a deadline thing that if it is not done, when not documents are not given within 60 days, the applications can be, what we generally do is we return the application saying that always you have the liberty to come back with all the papers when you have them actually. So the general things that on prima facie on the cases where the document applications are rejected is, the first thing is that RD1 is to be filed within 7 days of EOGM. So this is the first and basic thing. Like RD1 is filed after 1 month, 2 months, or even on the 8th day sometimes due to technical issues, V3 issues in the last few months. So, but RD's hands are really bound. We cannot accept any application wherein the RD1 is filed even a day later. So it is a very important thing for all the persons who are filing schemes in RD1 to be very, very prepared and be aware of all the V3 issues, technical issues that can happen. You have to be within 7 days with us, otherwise your application will not be accepted. So this is the first very general issue and which we face, and we can't do anything about it basically. The delay condonation is not in the hands of RD. So you have to be very careful with filing RD1 within 7 days of the meeting. Then there is a CA9, as rightly it was pointed out, that in the Act it is said that it has to be served to ROC and OL. However, we insist that the scheme should be given to Income Tax Department also. And also if any other regulatory authority is there, which you are governed by, like RBI, SEBI, BSC, NSC, RERA, Civil Aviation Department, or any other authority by which your companies are bound, then you should also give a notice, CA9 notice, along with the scheme copy to that authority. So this is another thing that you should keep in mind to save your time basically, because otherwise if RD tells, then again 30 days notice will have to be given to that authority. And then CA, after CA9 comes CA10, in which the difficulties are that CA10 you should be very perfect in saying that when you are filing the application, it should not be older than 1 year, because the CA10 application says that I am solvent in the last year, so it has to be within a year. So you have to be very particular in seeing that, because if it is older, then again you will have to file declaration of solvency, and the whole process is again cumbersome and will be time consuming. So that is something which you need to take into account. And CA10 generally what people do is they just give the CA10 format, assets, liabilities, and they just give it away. But you have to just read it, because it says that it has to be accompanied by a board resolution, by the statement of assets and liabilities, and by the auditor's certificate. So a specific auditor certificate is needed along with the CA10, which certifies that all the assets and liabilities are seen by me, which is attached appended to the CA10. So this is a very important point which people generally miss in all the applications. And the whole CA10 along with all these documents should be filed in GNL one with the ROC. So this is a major issue again where most of the applications are losing time on basically. So you can be perfect in this. And one more thing is a declaration of solvency, which means that the company should be solvent. So the companies come to us, CA10, wherein the transfer company may have a negative net worth. And when we ask them, we're like, how have you come? Because you have a negative net worth. So the company's answer is that I have a loan of so and so from the holding company, and my post amalgamation thing will be solvent. Post amalgamation, the company may be solvent, but Western region looks at the pre-amalgamation status of both the companies, of the transferor and transferee. So you have to be very careful, and it has to be positive pre-amalgamation, at least in the Western region, for the application to be considered. And also the general mistake that people do is in NCLT matters, merger matters, there is generally dispensation of shareholders meeting, because it closely held companies, and creditors meeting also. So in this case, section 233, the EOGM of members is mandatory as per the Act. If we go by the reading, So you have to have a meeting of shareholders. That is compulsory. And but however, the creditors meeting is in the act only they said that if you give consent, then meeting may not be held. So this is one consideration to be held because people come with consent. So now with lot of, even when people come to meet me, I give them a lot of this thing that you have to be very careful and you have to conduct meetings. Even if your shareholders are sitting outside, you can always have a VC meeting and comply with the meeting part of it. So there your application will at least will be considered. And as rightly mentioned in the case clause and everything, the present and voting concept is not accepted. So 90% of shareholders and 9/10 value of creditors is the minimum basic thing that you need to have before even thinking of making an application. So you should have that majority. And we have a regular checklist which is there. So we generally ask for auditor certificate for the number list of creditors, list of members and everything. So that is there, and the valuation report is one thing that we ask for small companies amalgamation, and in the case of demerger, we insist for a valuation report, like what will be the swapping ratio and how much shares the transferee company will be given to transfer. And then one more thing also which we realized, like MGT 14 is not filed for the meetings that are held. So that is also something which you need to be careful and file MGT 14, GNL 1 and everything. And regarding the appointed date, if it is really antedated, like if you are filing in 2024 and the scheme is and appointed date you are asking for is 2020 or 2021, then you should have specific reasons. As per the MCA circular, if you have an antedated appointed date, you should have a specific reason for it. And while drafting of the scheme, we have seen certain things which are like the consideration clause, which is very important, is missed by people while drafting of the scheme. So you should be careful, and at least in the consideration clause, even if the shares will be cancelled or something, you should mention that this will happen, and consideration clause, because all the shares of the transfer company are held, you have to accordingly make that consideration clause. Because without consideration, any scheme, it will be voided. And then in at least Western region, what we follow is change of name clauses we don't allow, change of object clauses we don't allow, because you need to follow that specific provisions for changing of name and changing of object. Through the scheme, we don't allow those changes. So this is what it is about. So these are the regular mistakes which really take time. At least 2 months are gone in this. Like even after giving the checklist, people don't realize, and like there's some interpretational issues always. Like we think it in one way, and we have seen through so many things. So these are the basic things. So if anyone has any issues, then we can just talk about that.
Madam, just I want to ask one question. Are there any common pitfalls or error in documents that companies should avoid, which always you are finding?
Yeah, these are the things only. Generally, in the scheme there will be problems. In the procedural things there will be problems, and then there will be peculiarly like case to case basis. There will be certain things. Generally, there are procedural issues.
Okay, okay, proceed. And
Yeah.
are there any mechanisms in place to expedite the review and approval process?
This is, you have to be very careful in all these things. If you do this, and our ROC and OL reports also come within time now. So what we have done with the 60-day circular coming in, when we send the checklist to the company, because RD1 is filed with RD office. So ROC and OL don't know. They are only involved in the state of CA 9 and 10.
Okay.
So what we do is we inform the ROC and OL also that this matter has now come to us, so you kindly send your report.
Okay.
So
Yeah. Please complete.
Yeah. So if the documents are proper and in line, and the reports are also there, then the approval will happen in 45 to 50 days.
Okay, in your lifetime journey of this fast track merger, can you share some success story where you find that this is the perfect case and it we have done and it will be a win-win situation for everybody? Any case which you find?
Yeah, cases, I'll not name those cases because these are all records, but certain professionals who are doing day in and day out. See, they know, okay, abhi ye maine mistake kar li, abhi I will not fall into that thing again. So they get, some people are involved only in filing mergers and 233 mergers, they specialize in. So their cases, what we get in our office, they are very perfect and specific. So there, in cases I have done my fastest merger in 40 days.
Okay.
Yeah. So it is with looking at the PPT time and timing of 250 days in NCLT. I think this is, and this all thanks to sir, because he is the competent authority who does it.
Okay. Manoj, can we do one thing? We have questions also.
Yeah.
So just show it and quickly we can give answer. And wherever Madam Manoj is giving answer, wherever you think something, you just come in between. Manoj, can you show this?
Yeah, sure.
Because I have to cover all for 50 questions today because 30 questions, 29 questions already there and 50. So Manoj,
Yeah. Is it visible?
Yes.
Yes, sir.
So Manoj, this first question which I will ask you, and
Okay, you are asking from the questions which are
I'm
coming
asking.
right now?
I'm asking, yes. Does
Okay.
section 233 apply solely to merger or does it encompass demerger also?
So I think it is very much clear that even subsection 12 of the section 233 clearly says all kind of a scheme of amalgamation which is covered under section 232, 230 scheme of arrangements can be covered under this section.
Madam, when I was taking a session, I was telling earlier company law 1956, there was only one section of merger which was, all other section was complicated or restrictive. But this was the only section of merger and amalgamation which you can do anything under the earth or over the earth. So that is, so this is also very clear that people should not confuse that demerger is separate from merger. Madam, you have any point in this or it's okay?
No,
Yes,
we have also
it
got a clarification from Mantralaya that demerger is included. So we allow demerger also.
Okay.
So actually, this is just because of the heading of the section, which says that merger involving certain class of company, people get confused.
Okay.
But say if we go to section 232, it clearly says merger of a company or a division thereof. So division includes demerger. So that's why demerger is fully covered.
So Suman, wherever you want to add, just raise your hand. I will take you there. Yeah, Manoj.
Yes, sir. Yes.
Yeah, Manoj next. Can the regional director propose alteration of scheme even if the registrar of companies and official liquidator have raised no objection? Madam, what is your view?
Yes, because as I said, certain clauses what we don't allow. So what we do is sometimes we call for altered scheme, or sometimes what we do is we just say in our order that so and so is not allowed, and you have to follow the process. For a name change, say, for an object clause, say, like that.
Okay. Sir, generally we have seen that we generally make the scheme, then we specifically put the clause that the scheme as provided or with such amendment or modification as directed by RD would be
So
approved.
earlier, like in other cases, NCLT, you are giving this power to NCLT, modify.
It is inherent power with the NCLT. So yes, the same power goes to the regional director also.
Okay. But it will not impact ROC and official liquidator approval?
No, it is a superior authority. If RD is directing, obviously it is binding to all.
Okay, if RD is approved, RD is modifying, then again you have to go to official liquidator and registrar companies?
No, it will be simply filed post approval. The scheme will be filed with INC 28, which is the notice to original or ROC.
Okay. Next. In what circumstances does the regional director refer the scheme to NCLT? Madam, what is the which circumstances you refer? Or how many cases?
In my experience, we have not referred any scheme to NCLT. Generally, what we do, is that we tell the applicant to correct the scheme and then bring it as to we give the liberty to file afresh. That is what the process we are following. Because we don't have the power of rejecting. We need to forward it to NCLT. Then again, it becomes a time-consuming exercise. So we generally what we do is we return it.
Manoj, Suman, have you come across any circumstance?
Yes, sir. We have just discussed the IDFC case and other case where the regional director has found the scheme not suitable to be approved. One for the ground that the approval was for the of the present and voting. 52% of the shareholders came in the meeting and they voted in favor of the scheme. However, it was not 90% of the entire share capital. So regional director rightly rejected the scheme, but the applicant went to NCLT and NCLT found it suitable to approve the scheme. So that was one case. Another case which we discussed was relating to certain, the valuation report was not provided, and there was certain part of the scheme which was not suitable to all the creditors. So regional director rejected the same, and NCLT approved considering all the facts and circumstances. So there is subsection 6 in the section 233, where there is a power. If the regional director does not find the scheme fit to be approved, it may refer to NCLT. Similarly, under the normal jurisdiction, and people go to against the order of RD under section 233 to NCLT, and NCLT invariably consider those applications.
Okay. Next. Should non-attendance of shareholder creditor at their respective meeting be considered as implied consent when determining a approval threshold for a scheme?
I think no, that is very much clear. You need positive consent of 90% of the total shareholder and each class of creditor. Shareholders' consent has to happen in the meeting of shareholders, whether virtual or physical, in the form of AGM or EGM. And creditors' consent may be in the form of written consent through affidavit or in the meeting. But it has to be 90% of the entire value, not the number present and voting.
Okay. Madam, you have any view in this?
Yes, I agree with this.
Okay.
I think though we have found that NCLT has overturned those cases in two of the cases, but
the law needs to be amended for this.
yes,
We
but
do
the law,
what the
yes,
law says.
the RD has not inherent power to exempt it. One cases we have found that regional director Kolkata has approved even at a lower 43% voting. So I think they have gone beyond, but nobody challenged it, so it's fine.
Yeah.
Okay. One question I will ask you later on when other people will join. Just jot down the point on uniformity, that whether the all regional directors office are working the same SOP or they have a different interpretation. Okay.
Right.
Can a fast track merger be enforced between a listed and an unlisted company?
It can be so.
I think they have discussed two cases. There are a few cases, but the condition is that you are able to get consent of 90% of the shareholder in the meeting. So if the number of shareholders, even in case of listed company is less, and the company is holding company and wholly owned subsidiary, then
Manoj, point is what law says it's important. What practical problem you will face, that is separate.
Yes.
If there is a listed company which is small, can be listed company be small?
That is also a possibility, yes. Legally, it is possible because there is no minimum capital threshold for existing listed company. Though new company going to the listed may not be fulfilling this condition, but old companies can fulfill, yes.
And second is the listed company can be subsidiary and
holding company and wholly owned subsidiary cases can be there. Yes.
Yeah. So it means that these companies can do this. Only issue is the listed company, if it is coming a small capital, that can be. So the answer is positive. This is possible.
Yes.
Have you done any case like this?
Yes, we have done. In Optimus Infracom case, it was, I think, in 2018. We got the approval from regional director Delhi.
Madam, how many cases you have handled for fast track merger and list of where the listed companies are involved?
Very, very rare. I think out of 200, I would say 10 maybe.
Okay.
One case. So that case, the West Corp case was there. Yes, it is for regional director Mumbai only.
Holding subsidiary wala kiya hai.
Yes.
Next. How should the accounting be handled for fast track merger in the financial record of both the transfer and transferee companies?
Sir, there is no differentiation in accounting process with respect to a scheme approved under 233 or 232. It is simply a scheme of amalgamation or merger, and hence the normal accounting standard AS 14 or Ind AS 103 as may be applicable should be followed. So I have already discussed in the presentation what is the legal position under section AS Ind AS 103 or AS 14 as may be applicable, and that should be in conformity. Accounting should be in conformity with those provisions.
Suman, you have any view in this?
Accounting certificate is required. It is same, sir. So there is no difference between normal merger and
Sir,
fast track
so
merger.
RD North generally asks for accounting treatment certificate as applicable in case of 232 normal merger also, in case of fast track merger also. So we are following that process. We are seeking this certificate from the statutory order of all the companies involved and file it with RD so that there is no.
Madam, Western RD Western is doing the same principle, or they
Same,
you?
same principle. And we
Okay.
also add a clause in our order also that they be following that accounting principle.
Okay. Next is, it is permissible to alter the scheme of amalgamation filed under Section 233 of Companies Act. Madam, is it permissible?
Alter a scheme means what? Like we'll again have to go to the board and again have to go to the members and creditors if they are altering the scheme.
So
Then
it will
might
be a
as well
new
withdraw
scheme
it and
altogether.
make it again
Practically, it will be a new scheme altogether.
be a new scheme.
So it means ki permissible is not permissible. If you want to change it, you go to again the same process.
If there are minor changes and you can convince the regional director and he passes the order to modify, then it's good to go without getting time involved.
Madam, have you in the past, are you allowing any type of merger where people have changed the scheme without changing the substance?
No, generally there are no such requests. Generally they withdraw the scheme and they come afresh.
Manoj, have you done, have you?
Ma'am, yes, practically, ma'am, like one of the case I remember where during the process, the name got changed. So it was not material
That
in
is a
any case.
factual.
So that
That
was
is a
pleaded
factual.
while before the RD, and RD passed the order that there is a modification and taken on record. So this kind of smaller
Now we
modification.
take so less time. There is no need. No, you can change your
Yes,
name
yes.
afterwards.
Okay, okay. Can the appointed date for a scheme of merger be retrospective or futuristic or even based on
Even
any
yes.
event?
Yes, I think appointed date provision is similar. There is a circular of MCA which clearly says that the appointed date can be 1 year backward or forward. And in case you want it to keep it much retrospective, then you need a specific reason to justify that. So that provision would be applicable here also.
Madam, have you rejected or have you any type of things you have done for appointed date where there's a issue?
Appointed date, yes, we had a very antiquated, like we had a merger in 23, which had an appointed date of 2020. So, but they had a specific reason which they had also mentioned in the scheme, saying that RBI had told them to merge the company with that company. So there was some issue of license and everything like that. So considering the specific reason for that, so then the appointed date was selected on that basis. So we had allowed that much.
Okay, okay. Is there any additional tax implication exemption in case of fast track merger, Manoj?
So for income tax, there is no differentiation between merger approved under 232 or 233. So if the condition of amalgamation as prescribed under Income Tax Act are getting fulfilled, it will get all the benefits of tax. So there is no additional requirement or implication.
Okay. Suman, you have any point in this or?
No, sir, it is same, sir. There is
Okay.
no.
Can a company with the ability to pay its debt yet with the negative net worth still be deemed eligible for the purpose of fast track merger because solvency issue is there? So, madam, what is your view on this?
No. On paper, it has to be positive.
Okay, Manoj.
How do you ability to pay its debt with negative?
So ability to pay debt is important factor. So I think the form CA10 clearly says that there is a column for book value and the realizable value. So in case the realizable value of, let's say there is a land which is booked at the present in the book value very less, and the fair value is much larger, which is certified by some registered valuer, and the company is putting that, and based on that it becomes positive. Then this can be of the scheme can be approved, and that is possible because the solvency is basically based on the capacity to pay the debt. So
Okay.
that let's say the total liability is 10 crore and the value of property is 11 to 20 crores, then you can clearly claim that it is a solvent company.
Okay. Should the fair valuation determined by the board of directors under the scheme of asset and liability be accepted, or should it be certified by an independent registered valuer?
So wherever you are revaluing any asset, it is always advisable or required to have it revalued by some registered valuer. under 247 of the Companies Act.
Madam, are you following the same same practice?
Not very, but we generally, as for a valuation report, we are not very fussy about independent valuer. But generally, people follow the registered valuer concept.
Okay.
Yes, because board has to give declaration and two directors
Yes.
have to give undertaking. So the undertaking has to be certified,
Certified by-
supported by something.
Okay. Can companies opt for composite scheme or implement alternative scheme using the fast track route under section 233?
Composite scheme means yes, fast track merger. So it can be composite scheme because section clearly says that all kind of arrangements which is available under section 230 can also be under 233. So clearly a scheme, composite scheme having merger, demerger together can be filed under 233. There is no restriction as such. But alternate arrangement, I could not understand what is the alternate arrangement.
So
Implement
basically,
alternate.
I would like to emphasize this question on this question. Basically, in composite scheme of arrangement, I had word in RD North. So they used to say one time you should file one scheme only. Like if there is like merger also planned in the scheme, demerger also planned in the scheme, then they may not approve the scheme. If there are two transfer company, three transfer company merging with one transferee company, then it is not composite scheme of arrangement. They may approve it. But if in single scheme, like one company merging with another company and that another company merging with third company, then it may create problem. So it may be problematic scheme.
Okay. Okay. Madam, you have the same view?
Similar.
Okay.
And even mixing up holding subsidiary and small companies also, we are not in very much.
Yes,
We
ma'am.
can
That is
file
clearly
separate.
written in the law itself that there
Yes.
be
You
two
cannot.
small company or one small company and one startup. That is
Yeah.
possible.
Yes, that is possible, but not holding subsidiary.
Not holding company and a small company. That is not possible. Yes.
Okay. Whether a merger or step down subsidy with the ultimate holding company comes under the purview of section 233.
Section 233 clearly says wholly owned subsidiary. So wholly owned subsidiary is also wholly owned subsidiary. And that if that condition is getting fulfilled, there is no issue.
Okay. Madam, is the are you the same follow?
One case, I suppose, I think one case we have done. Step down subsidiary. One
Okay.
or two cases we have done.
In case where there are more than one transferee company, can the parties of the scheme file a single application with the regional director?
Again, it may be a composite scheme. So generally, as Suman was saying, that the regional director generally does not prefer a scheme which is very complicated. It says that there should be two separate schemes so that it is simpler to approve. But legally, it may be a possibility.
Okay, Manoj, now we have 47 questions, so we have to be very fast. Okay, so I will ask, so very shortly some now you have to give, and we have only 35 minutes. And appointed date is a must in a scheme and can be prospective or retrospective. In the fast track merger, certain companies with certain relationship or eligibility will come under the category. Now, should the relationship exit at the time filing the application, or it should be there on the appointed date?
Sir, at the time of filing is the important factor, not at the time of in the life at past what was there. It is not important.
Okay.
At the time, holding company and wholly owned subsidiary relationship should be established.
Manoj, normal
Right.
question you give answer. Madam will add value in this, and some questions which are directly related to the reason.
Wherever I'm not agreeing, I'll poke
Yes,
it in.
ma'am. Sure, ma'am. That will be good. I think
Yes.
I'm
Okay.
giving it based on my practical experience, so you can.
Okay.
Yeah.
Can two wholly owned subsidiary be merged with the holding company under the fast track? The section talks about subsidiary and not the subsidiaries.
Yes. Two or more companies can easily be merged into one.
Okay.
Amalgamation.
Okay. Under the FTM route.
Fast track merger route. Yeah.
Fast track. The new word also people coin. Na? I understand creditor meeting can be dispensed by obtaining the consent affidavit. Can the same be done by shareholders meeting?
No, I think ma'am has clearly mentioned that there is a need for meeting of shareholders and creditor, and it is more important that to understand that the filing of CA 11 depends upon the date of meeting of shareholders. It has to happen within 7 days. So unless there is a meeting of shareholders, this date can never be achieved.
Okay, okay. Is the transferee company required to send notice under section CA 9 to the official liquidator of transferee company, or the same should only be the OL of the transferor company, since OL of the transferor company would be involved in the merger process?
Practically, yes. What the question is correct, that we may serve only to the register transfer company's OL, but it is good to file the copy of scheme to all the to both the ROCs and both the official liquidators, so that there is no confusion at a later date.
But if the ROC and OL is different state, then
Yeah, so in all the states, you have to file ROC and OL. Only the final approval application should be filed with the regional director having jurisdiction over the transferee company.
okay, okay. Can holding your subsidiary company go under fast track route, which is not the wholly owned subsidiary?
No, it is only available to the wholly owned subsidiary unless they fulfill the condition of small company or a startup.
So, madam, have you come across any case where you have rejected or okay? It is okay. It is compulsory to file CA 10 basis audited accounts, since March 24 accounts would not be ready for now for private companies.
So I think it is at least the certificate. There is a requirement of certification by the statutory auditor. So if 1 year is already gone and balance sheet has not yet ready, you may recast the assets and liability schedule and get it audited by the statutory auditor. And if they are really willing to certify it, then you can give this based on unaudited figures.
Okay, okay, madam, you have any view in this?
Yeah, what we do is we try them to get a provisional financial statement, say as on December or as on January or
Yes.
something like that.
Generally,
And
we
then
also follow
they're
the
ready to-
practice that
yes, yes, yes.
it is
And
not
then
6
the
months
auditor also
older than
tells
6
us
months.
that CA 10 is made.
Yes.
Okay. With respect to statement of asset and liability as the 31st March, if the financials are already audited by May end, being a listed entity, can the director use the audited financial to certify the solvency, or it is mandatory that the separate certificate need to be obtained from the auditor? The section seems to be silent on this aspect.
It is more about the format. Format prescribed CA 10 clearly says that there is a certification clause from the statutory auditor. So you have to get that certification done by the statutory auditor. Otherwise, the form will be incomplete.
Okay, okay. So madam is also agreeing on this point.
Yes.
If the number of creditors in the transferee company are very high, that is the process of the conducting the creditors meeting, can we send the affidavit asking for approval and dispense of the meeting? Practically, do RDs approve if the 50% number criteria is not met, and we get approval from 90% creditors in value term alone?
Yeah,
Madam,
so there is no concept of 50% or more. It is only 90% in value term.
90% in value.
so there's no question of 50% number terms and other thing.
Yes.
Okay, what about the operational creditor?
Whoever is the creditor, there will be separate class approval. So all secured creditors would be one class, all unsecured creditor would be one class. For each class, 90% in value, you have to get the no objection.
So how this confusion has come in the mind of people that 50%?
The confusion coming from the concept of meeting of creditors. So if there is a meeting of creditor, let's say there are 500 unsecured creditors in a company which is going for fast track merger, and only 20 people are coming in the meeting, and they are not 50% of the total number, but they might be having 90% plus value, and they are giving the consent. So that would be fine for ROC purpose, RD purpose.
Okay. Madam, in case of reverse merger, holding getting merged in the subsidiary company, then it is a case share get extinguished or cancelled?
No.
It is there, no, in the section it is there. It may get cancelled or extinguished. You just need to mention that in the consideration clause. But it will not amount to reduction. So that is what people generally write in the scheme.
Okay.
Yes. So sir, here in case of reverse merger, obviously the cross cancellation would be for the subsidiary company's capital. Reverse the holding company share would be under entitlement ratio would be distributed among the shareholders of the holding company. So
Okay.
that entitlement report need to be produced to the regional director.
So Abdul Qadir has mentioned, can we get PPT? Yes, all will get PPT. Okay, next. Can transferee company allot shares after filing the merger application with NCLT? What are the provision or issue in this?
Sir, legally, there is no restriction on the transferee company to continue with its operation, including changing of capital, etc., because there is no swap ratio impacting the share capital of the transferee company. The transferee company, there is no extinguishing of shares of the transferor company, not the transferee company. So transferee company can continue, and it can obviously post appointed date, it can have different bit of capital. That is allowed.
Okay, madam, okay. If the registered office of holding company and wholly owned subsidiary, which will get merged with the holding company, are situated in two different states, Delhi and Bangalore, will there be any regulatory hurdle while processing the fast track merger? Because there were two RD will involve. It is recommended to change the registered office of the or wholly owned subsidiary to registered office of holding company and then apply for fast track.
No, there is no such provision. Law is very much clear that the application for approval to the RD would be made to the company which is continuing company, that is the transferee company. So even if their transfer company have different RD jurisdiction, their involvement is not there. Only ROC and official liquidator will give their comments or observation, if any.
Okay. Okay. Instead of convening creditors meeting, can we get written consent of 90% creditor?
Yes, that is clearly written.
Madam, you can have a physical meeting, or you can have a virtual meeting, or you can get in writing. These are all
Yes,
three.
yes.
Okay.
If there are very less creditors, people get NOC and just.
Yes.
In case of demerger, who would be the applicant company?
Who would win? Both the company. Okay. So resulting company would be the applicant company for RD. So obviously the order will be saying that it is acquiring the business of the transfer company.
Madam, this interpretation is right.
Actually, both are applicant company, demerged company and resulting company.
Yeah. So this question is coming where there are two different RDs jurisdiction. In that
Yes,
case, obviously the transfer resulting company's RD would pass the order.
Okay. The company has uploaded, disclosed the information on scheme of arrangement under Regulation 30 material disclosure with the stock exchange immediately after the board meeting. Regulation 37 through exempts certain procedures such as obtaining NOC from stock exchange for merger of holding and wholly owned subsidiary, but require a disclosure to the stock exchange. In present case, have disclosed the scheme already under Regulation 30, but it would be mandatory to disclose to stock exchange under Regulation 37(6) as well. If yes, is there a specific timeline to make disclosure of the scheme under Regulation 37? What is the prescribed fee for making the disclosure under the Regulation 37(6)?
So yes, so SEBI master circular wherever is applicable in case of merger of wholly owned subsidiary with the holding company, which is a listed company, there is a specific exemption from the no objection from stock exchange and SEBI. However, the law clearly says that the scheme and its content must be disclosed as per under Regulation 37. So for under Regulation 37, we have to file the scheme with stock exchanges through the portal, and it will be uploaded for public viewing. So it is separate from the Regulation 30 disclosure, which happens immediately after the board meeting. And there is a prescribed fee of 25,000 for this work from the stock exchange.
Madam, all are private companies. If companies are holding shares each other, or say cross-holding each other's shares, can be merged under fast track merger?
Like they should be holding a subsidiary. They should fall within 230. Private companies, but they should fall within their definition.
Yes, if they all are small companies or startups, then it is possible.
They can do.
Okay. Two companies not doing any business and need both to be merged with other doing business activity are located in Bhopal, MP. I think there's any problem in this?
No, I don't think there is any problem there.
Solvent they should. Not
Yes.
do business.
Okay. If we are not doing business, but solvency ratio is there.
Yeah. Solvency is the condition, yes.
Yes. If the parent company registered office is in Haryana and wholly owned subsidiary registered office in Bangalore, do we need to file for a merger with both RT?
No.
on-
It will be filed with the
Transferring.
transferring company.
Transfer.
Okay. If 100% shareholders are providing written consent for fast track merger, it's necessary to convene a general meeting.
Yes. Still meeting of shareholder is required. We have
Madam,
to
have you exempted any company which is submitting this type of letter? No. So the point is, for creditor it is allowed.
It is
For
allowed.
shareholders meeting, you have to have a physical meeting
Physical
or virtual meeting.
Virtual also is okay. If some of the
Virtual is
shareholders
okay.
are in foreign countries, virtual is also okay.
Okay. In the state of Delhi, the Stamp Act is not clear on the payment of stamp duty on merger order. Please clarify the issue.
No, it is clear through the judgment of Delhi TARS. The scheme approved by the NCLT or RD is subject to stamp duty at the rate of 3% on the consideration value. In case of wholly owned subsidiary and holding company, there is no issuance of shares, so consideration is not there, but the cancellation of share will be deemed consideration. That is also approved, confirmed in many of the judgments.
Okay. If ROC or OL is not giving his report in time, then how it possible to complete 60 days? It is pending due to ROC and OL. Madam, what is the view in this?
Leave it to us. Don't worry.
Now,
We will get it.
considering these facts, I think, ma'am, I think because of this only the circular has come specifically saying that all the scheme must
But
be.
it is now very much streamlined. I'm so happy with the circular because I
Yes.
was only very this thing ki kaise karenge 60
Hmm.
days. But I'm very happy. The pendency as of date is always 20 applications. With the fresh new applications, every month we get 10 to 15 applications. But the
Okay.
response is also so good. So always there are 20 applications pending. जो पहले 50-60 रहती थी. People have
Okay.
also become active in giving documents, so that is also a good thing.
I think this question is different, but Manoj, if it is coming, MCA to consider providing offline or physical mode for submission of document given right timelines and technical issues. So, is it?
This ma'am has clearly said that we will not be able to give exemption even if it is because of the portal problem. So at least RD1 should be filed on time. ROC and official liquidator service may be through physical mode or any other mode as you deem fit. But RD1 must be filed within 7 days from shareholders meeting.
So, if 7 days, you mentioned, madam, about the compounding, that RD has no power. So, who has the compounding power?
There is no compounding here, sir. It is only rejection, pure rejection. They will not consider.
Not compounding. My mistake.
I think it was the
Condonation of
CG1
Delhi.
was there. I think before a year or so, CG1 form was there for delay condonation. So people used to go there and do that also. But now I suppose that has halted or something like that, and it's very time consuming also. So it's better to, because there are very small shareholders, so they immediately get shorter consent and fresh meeting GNL MGD 14 and they just get it done.
Okay. What is the timeline for filing a NC 28? If approval order is passed without referring to NCLT, and order after NCLT order, an application referred by RD to NCLT, also clarify on combination of authorized capital to of transfer and transferee company.
So that is so first part, I think law is very much clear. The provision of 230 is applicable. So consolidation of authorized capital fee would be available, would not be a challenge in the scheme.
Okay. Madam, how many cases you have or you are approving all companies authorized capital merging with transfer? Okay. Any case which has come which you think you have rejected or you have not accepted because of any reason?
Combination of authorized share capital, no?
Yeah.
It is as per the scheme, it is there. So then you pay the fees, whatever is the increased share capital, and then there is combination of it.
Okay, suppose some company is not writing. Are you giving from your side also, or if they are not writing, then you will not allow?
In the scheme, it is there. Generally, in the scheme, it is there.
Okay.
Combination of authorized share capital is important clause.
Okay.
Similar to consideration clause.
Why to leave the benefit of the fee already paid to?
But this is my choice. If I don't want, I can do it.
Yes. So entire section 233 is your choice. Even if you are eligible, you are a small company or you are doing merger of wholly owned subsidiary and holding company, you can go in the normal route if you think so. So it is just, it is
There
a choice
was
that
one
the,
case where they said we don't want combination of authorized share capital. Recently, we
okay.
said there's no clause here, we don't want, let it be.
Okay,
Actually,
okay.
there may be practical difficulty. There may be
Yes,
practical
practical.
difficulty at the
Yes,
time of combination. The regional ROC office asks for the proof of payment of old stamp duties. Sorry, old fees, ROC fees, and sometimes the old companies don't have the proof of payment. So
Yeah.
that is a challenge. So it is better to let it go than fighting at ROC level for a long
Okay.
time.
What is the exact difference between the appointed date and the effective date? Please elaborate with example.
So, so
No,
appointed.
don't elaborate. Just give.
Yeah, simply appointed date is the transfer date from which the assets and liability of the transferor company gets transferred to the transferee company. Whereas the effective date is the date when the scheme is approved by the RD and it is filed with ROC for implementation. So effective date is not not a legal date. It is just a technical thing that scheme approved scheme did filed with ROC. So that is the effectiveness of the scheme.
Okay. Can checklist of fast track merger be available, Manoj? You have, please send it to Manju Mundra. Okay.
Okay.
What kind of objection ROC and OL may give? Madam, when you are receiving, so you are receiving with the objection, or I can come after removing the all issues?
Actually, CA 9, when it is served to the ROC and OL, then ROC and OL give their observations to the companies. So generally, then thereafter they remove the objection, then do the scheme accordingly. So that is, and afterwards also when we get ROC and OL reports, we get certain observations. So then if we have some doubts, then we get clarification from the company. And
Okay,
then we
what types of objection ROC and OL gives?
sometimes it is like the negative solvency thing is there. Sometimes the accounting things are there. So
Okay.
as some sort of things are there. So then we ask for the clarification, and generally they are all procedural objections. So the scheme is not affected by it.
Okay, okay.
Sir, practically we have found that ROC sometimes give objection relating to, let's say, MGT 14 not filed, something like that. This kind of objections are also there. So if there is a delay, it has to be filed with delay, or if not possible, then this compounding or adjudication, as the case may be, need to be completed. So those applications need to be filed before it is approved.
Okay, Suman, have you faced any objection of ROC and OL which you have in practical cases?
Once
you-
again, sir.
I'm just saying.
Objections from ROC side.
ROC and OL side. What
Officially
type of objection you have seen?
Sir, basically, in financial, if there is some filing of form are pending, and if there is some misleading information in financials, then they used to object it.
Okay, okay, okay. Okay. Now, in case of FTM, the wholly owned holding company with its subsidiary, there is a no share swap. So it is a valuation report mandatory.
No, sir,
Holding
holding and
subsidiary
holding
is not
subsidiary
mandatory.
merger.
Not
No.
mandatory.
It is not mandatory.
Okay. Now I have to start a rapid round. So everybody should be very strict because I'm finding more and more questions are coming. Why valuation report is required and when it is to be sent?
Why
Small
valuation?
companies, no? Small companies may be required, and reverse merger, demerger.
Yes.
Okay.
Reverse merger or small company or let's say startup companies, valuation report is very important.
Madam, in case of scheme where transferee companies from another state, is OL application necessary to be given to the both state?
The sorry, I did not get it. Transferee company is there where you file the RD1, and wherever the OL is there, then you serve the ROC and
So
OL.
both the places.
Not both the places. Generally, even if you, Manoj ji has said very safer side के copy चली गई तो कोई problem नहीं है. But we get report from the where the transfer company is situated, where it will get dissolved without binding.
Yes.
That OL will give us report.
So you mean to say RD where the transferee company is there, it should be.
Yes.
But where OL and ROC, the place where the transferor company
Transfer company. Even ROC of transferee company also you need to give. No,
Yes.
because it is
ROC of both the states are
हाँ.
RD of transferee company and OL of transfer company. That is.
I'm just simplify this. The OL of transferor company, ROC
Yes.
of both the company, and RD of the transferee company.
Transfer company. Yes. I mean,
Okay. That's clear. In case of scheme, this my form RD1 is filed within time, but after few days received email for resubmission. That is a technical issue. Or any other point, madam, when the resubmission, because somebody saying I filed, then I got a call that resubmission.
Generally, in the Western region, what we follow is we don't send the form immediately for resubmission. Once we receive RD1, we send a checklist saying that you give all these documents in physical.
Okay.
So when we get all the documents and if they are improper, then we again send an email. People don't reply to us after 60 days. Then we send form them for resubmission. Then they wake up. So then
Madam,
that is
okay. Registered NBFC merger is allowed.
registered NBFC. Yes, if it is a holding subsidiary.
Okay.
And if it falls under 233 ka bracket, then it is
So
allowed.
any company which is coming into this, whether listed, unlisted, or NBFC,
Yes,
if wholly owned subsidiary, it can go, or it's a small company. Okay.
Yes, you get the required NOCs.
Manoj, in Delhi, there is a different rule, or it is same?
same.
Same. Okay. My form RD1 is filed within time, but after few days receive resubmission. However, due to some technical issue in B3 portal, my form not filled with the specific time and cancel the SRN by MCA. What to do? Madam, what is the solution of this?
You can go to the RD and then generally in 2 cases it has happened with us now. Resubmission issues are happening. So we are raising a CRF because they are again saying that you file new form, but new form will not work for 233 matters. The 7-day issue will again arise. So we are from our office we are also raising CRF and the persons are also raising tickets.
Okay. Should we go with the same document to NCLT when RD reject the scheme? Or we have to file a different?
No, if the RD is referring under subsection 6 of 233, then obviously the whole matter will go to NCLT and NCLT will take a call whether it will ask for shareholders creditors approval again or not, or all those things. Otherwise, if you are voluntarily going based on rejection by RD, yes, you will obviously go with the same scheme. In both the cases, the same scheme would be there.
Madam, how many schemes you have rejected?
We have written schemes. It would be like out of 200, say 30, 35.
But what is
because
the
of improper documentation.
okay? Only proper
Technical
document,
ground.
not on the
Technical
technical.
grounds.
Technical grounds.
Okay. We need to submit schedule of properties and statement of asset and liability to NCLT to get CTC from NCLT, but this is not mandatory in case of 233 merger.
Yes, there is no provision of this schedule of assets and liability. But in case of demerger, it is always advisable to attach the schedule of assets and liability as part of the scheme so that there is no confusion later on. Because in case of amalgamation, everything has to go. Whereas in case of demerger, there will be differentiation, which is going and which is not going. So
Okay.
it is always better to put all the details of the assets and liability which is being transferred.
Madam, where NOC of creditor should be in affidavit or on the letterhead?
Generally, we accept on the letterhead also, but if it is a foreign creditor or something, then we require apostilled because to just check the authenticity.
Okay. But certainly, registrar has denied to register the property in the name of the transferee company as it was not mentioned in the RD order. But recently, registrar has denied to register the property in the name of.
Understood. So this is a technical thing. They may not be knowing the concept of this fast track merger and RD's order, implication of RD's order. So you have to make a representation before the Tehsildar to get it done. But if they are not agreeing, then obviously you have writ petition. You have to file the writ petition. There is no other way.
Okay, Suman, the registrar of companies, when the fast track merger is there by RD, and it is not a court and not NCLT. So, are you facing any problem with the registrar office of the registrar of stamp duty or Tehsildar?
No, sir. Basically, they have clarity that yes, the merger order will be considered as conveyance. So if we are going and paying the duty, then they used to accept it. They have
Madam,
clarity.
have you received any complaint that Tehsildar is not registering?
We have not received complaint, but we received a notice like when they do the fair fire and something like that. No, so then they send a notice to our regional director also that if you have any objection, that means he has accepted it and sent notices.
Okay.
So I don't think there is any issue.
So it may be a challenge from smaller areas where, because property
does
can
not
be
know
in
the
rural areas
concept
also. Yeah.
of scheme.
So they may not be knowing this concept. So they have to make execute it first, and then it will be done.
Okay. Whether OL approval is required under section 233 and OL approval is required for demerger also.
Demerger, I don't think. There is no company which is winding up.
Only in case of amalgamation where the company is getting dissolved without winding up, official liquidator's report is required. It is not approval, it is a report to regional director concerned.
Okay.
So demerger is, if both the companies are continuing, then there is no requirement.
Okay. Okay. As NCLT, CTC includes statement of asset and liability.
Again, same question, I think.
Same question, I think this is.
So we have
In
replied.
case of demerger involving wholly owned subsidiary which is yet to be incorporated, can the appointed date be prior to the wholly owned subsidiary incorporation date, madam? What is your experience?
Yes, sir. Practically, there is no law which stops the company to enter into a scheme of amalgamation having appointed it prior to this. There may be legal contingency requirement because it will be more like a pre-incorporation contract. So that is also valid if it is approved. That is avoidable contract as per the law, as per the settled position of law. But it may be such cases because law says that specifically in case of demerger, law says that two company may arise out of the scheme. So it company is vertically split into two and two new companies formed as part of the scheme. So that is allowed, and if that is allowed, so obviously both the company would not be in existence at the time of filing of the scheme.
Okay, so you mean to say one company or maybe two, both the companies can be
Can arise out of the scheme also.
Madam, have you experienced this type of cases?
Not yet. Good question.
But we have got recent order of regional director North, in which they have allowed this appointed date 1st April 2023, where the company incorporated just after the approval of the board of directors.
So legally it is allowed.
Legally it is allowed. They have considered the case laws and then allowed.
Demerger is not that you are dividing two companies, you are dividing and making a new company, that is also.
Appointed is a date only to determine the asset and liability of the demerged company. So I don't think that on that date resulting company should be in existence.
Okay. In the fast track merger, will the RD having jurisdiction over the transferee company will pass the winding up order, or the order of RD having jurisdiction over transferee company will have the effect of binding up the transfer company also?
That is very much clear that the RD of the transferee company would pass the order and it will be binding on all the regional ROCs to wind up the company or dissolve the company based on RD's order.
You have same view, madam?
Yes, it is resolution without winding up. It comes in the part of the scheme.
Part of the scheme itself, yes.
Yes.
Law is very much clear that only the transferee company's RD would pass the order.
RD
Okay.
will pass the order.
Is there only 3 creditor and then do attend the meeting seeking approval of the scheme? How can one proceed? If there are only 3 creditors and they do attend, तो ये तो ठीक है, attend कर लिया, बढ़िया, ठीक है ना? I think he wants to say something different. Agrish, I think your question is not clear. Please correct it. If the transferee company is getting liquidated, then it is a valuation report mandatory.
Transferee company cannot get liquidated. It is not possible. I think there is a confusion. Transferee company is the company which is continuing.
Okay, if the transferor company is getting liquidated, then valuation report is mandatory?
No, it is. If it is a wholly owned subsidiary, not. If it is not a wholly owned subsidiary, yes.
Okay. Okay. Madam, if the company has given guarantee to some bank for secure debts of some other company, whether the NOC of the said bank is required, though the said bank is not in the list of creditor.
But it will be there in the charges, no, on the secured guarantee or kuch to rahega na.
Yes.
It will be there in the balance sheet. So then you require NOC.
Okay. Manoj, have you faced some different view?
Sir, because the list of creditor, its name would not be reflecting. So 90% for calculation or 90% it may not come. However, because of the agreement, guarantee agreement, corporate guarantee agreement, there will be an obligation casted in all circumstances. There will be an obligation cast that pre-approval should be taken.
Charges also it would be reflected. So it is,
yes.
NOC would be required.
Okay. Whether the consent of creditor should be in the form of affidavit or consent.
I think Madam clarified this.
Okay, it can be on both. Any paper. Can merger be wholly owned subsidiary and wholly company happen without consideration?
Yes, holding and wholly owned subsidiary, yes, there is no further consideration because it is already acquired.
Okay. What is a member meeting is conducted at a shorter notice before the creditors meeting? 7 days for RD1 should be from which date? I think Sheetal, you have to clearly write your question. It's not clear. Will authorized capital of wholly owned subsidy will add to the authorized capital of holding company? This is already there. Please send checklist to this. Thanks in advance for checklist. What is the 90% shareholder approval is not received? What is the recourse?
Recourse.
Can the same scheme be filed with the NCLT or whether it is to be modified?
So practically the scheme is, yes, scheme is talking about 233, then it cannot be filed with NCLT directly. So obviously certain modification need to be made in the scheme and then it can be filed.
Yeah, Suman, you were saying something?
If RD refers such kind of a scheme directly to NCLT, then process may be started from there. So in such case, modification is not required.
But RD would not consider the scheme unless 90% approval is there. So RD1 may not be filed. Hence, there is no provision, no concept of going under section 6.
Madam, your experience on this?
It will be prima facie rejected, 90%.
Okay. According to income tax of perspective, does section 79 override section 72A, Manoj?
No, both are different sections. So there is no concept of overriding. Section 79 is applicable for certain class of companies. Obviously, that benefit is available on separate.
Okay. Can NC 28 can be filled late with additional fees if not filed in 30 days, madam?
Which one? Which form?
INC 28 can be filed late with additional fees if not filed in 30 days?
I'm not sure. I don't want to go into this meeting.
Okay.
No,
Some questions which are on the policy matter. I know. Manoj, what is your view?
Sir, practically, INC 28 cannot be filed within beyond 30 days. So it has to be continuation of delay by the NCLT or RD. Unless they give the consent, the ROC would not take it on record.
Okay.
And there is a penalty provision under section 232, 10 and 11, whatever the section is. Yeah, so we have to be ready for that also.
Okay. Is prescribed fee 25,000 required if we are just disclosing the scheme since it is a wholly owned subsidy merger under regulation 37(6) of SEBI LODR?
Yes.
Not the regular merger where approval is required from stock exchange.
Right. So the BSE is charging 25.
25,000. Okay. How NCLT deal with the cases referred by RD? Whether a separate petition is required to be filed under section 2233? I think this question you have given answer. If it is same, it can go. But if
application has to be filed, yes, to NCLT referring section 233(6) as well as normal section 232, and then NCLT would take care of that from there.
Okay. INC 28 is the MCA 3 timeline for filing order item C.
Sorry, INC 28 need to be filed within 30 days from the date of order.
Okay. 7 days timeline for filing RD should be from which date? Creditor meeting date or shareholder meeting date, or whichever is later. Any.
Last of the meeting, yes.
Last
of the. But if you are taking consent from creditor, then it will be difficult. Then it is shareholders meeting.
Okay, filing time limit and INC 28 was not answered. You have given answer.
We have given 30 days is the timeline. Yeah.
Most of the creditors are paid off by time of the meeting of the creditors, and generally there are no creditors available who attend the meeting. How to manage this? So what he's saying, when you are filing, there is a creditor, but you have paid it. So that creditor is out. So how will you bring that? It's a practical question.
So it is if we are keeping the older date of list of creditor, we have to take latest list of creditor, and if it is certified by the statutory auditor, then whoever is left out, only those consent is required.
Okay. Private limited company established in 90 is a parent company of private limited company B, which is 100% subsidiary of A and established in 75. we want to use the word since 75 for a branding and plan to merge the companies, retaining the name of the company A after merger. How can we achieve this other than having company A merging with the company B? So they are taking the name of this company. Can it possible?
Change of name, yes.
Hmm?
Change of name.
Yes.
Change of name, so we are not allowing through the scheme.
Okay.
Then you can follow the process.
Okay. Regarding the statement of asset and liability, if the financial are already audited by end of the May, being a listed entity, can the director use the audited financial to certify solvency, or it is mandatory to obtain separate certificate from the auditor? The section seems to be silent on this aspect.
No, I think we have clearly said that the form
Very nice.
EA10 is providing the declaration, the confirmation by the auditor. So we have to take the confirmation from auditor.
Madam, last question. If the member of creditors in the transferee company is very high, what is the process of conducting creditors meeting? Can we send an affidavit asking for approval of dispense with the meeting? Practically, I think this is the same question.
This is the same question we have
Yeah.
discussed here.
50%. Okay. So, and this 37 also we have given answer. So, madam, 65 questions we have received. And then 5 questions we have received yesterday, 70 and 20 question Manish's presentation. So we have given answer of 90 questions. So now the time, we are just overshooting 5 minutes. Always we are following the timeline. So
Nice to see such active audience, basically, asking questions. Very good.
yeah. So I think it's a time to close this. So I thank Madam, you have saved our day because I just got a call from Vinod Sharma ji and Santosh ji. They are in the MCA
Sir
meeting.
also could not make it. He told he is in some other VC. So
Yeah.
he said, you just
So
carry on. I will not.
yeah, they are saying if we were free, then again, secretary and joint secretary meeting is going on. So anyway, you have hold the fort from one side and hit the sixes also. So thank you very much, madam.
Thank you.
Yogini, your knowledge is excellent, and you, whenever there is a issue, everybody can come to you and get your advice. And this type of session helps. Like so many questions were there where people are little bit confused, but by saying one and two things like where you have to file, where OL is there, where the transfer is a very simple questions. Everybody has given answer, and various other aspects also very clearly mentioned. So thank you very much, madam. As a ritual, we are just taking a last view for 10 and 15, 20 seconds about this particular concept of fast track merger, your advice to the public. So, yeah.
This session has also helped us a lot. Like you said, that stakeholders also get a very good view. It saves their efforts, and in addition, mostly it saves our efforts. Because in question answer में जो time waste हो जाता है ना, it saves a lot of time. Because
Okay.
today, if 200 people are hearing, they are giving answers to 400 more people. So it follows, and the common mistakes are not repeated. So it becomes very easy for us also. Because as I say, fast track merger is a very easy thing. It's a lot of procedure which you need to be following. If you file 1 or 2 schemes, I think you can be an expert in it. So
Manoj,
we are doing it.
Madam, I have received 5 more questions. The one question is looking very interesting. Final order of RD to be filed with the both ROC having jurisdiction over transferor or transferring company?
Both RD.
Yeah.
Both ROCs. Because you need to dissolve the transferor company, and hence order intimation is required from to ROC of the transferor company. Okay. Is INC 28 is not filed within 30 days? Usually RD will extend time. Answer is no. Are you giving extension, madam?
No. I think there is some delay continuation. Now it has remained or no, I don't know.
Acha, OL is questioning generally addressed to the transfer company. Is the transferring company also required to submit the document as per the OL checklist?
I think ma'am has clarified that it is not required. Okay. Official equity is jurisdiction of
someone your point,
basically,
yeah.
In transferring company, I don't think it is required.
No. I'm just
generally closing remarks he is asking for.
Yeah. So basically, in case of fast track merger, if everything is in order, then in that case only the merger can be faster, and otherwise it will be very slow. So place everything in order,
Okay.
then
So
Thank
fast track merger can be faster if you are in
But it has now really become faster. I suppose
Yes.
like everyone would agree. It
Yeah.
has become very fast because I have done mergers which were pending for 6 months, 8 months. So it
Yes.
like looking at that days now, this circular has really helps us and becomes easy for stakeholders as well as us also. That in 60 days, this way or that way, it is decided.
Okay. Okay, Manoj, your point.
Yes, sir. So, as I said, it is one of the very important and update or change in the company law, the fast track merger process, and it will cover a lot of companies. I think today they are not using this section. Lot many holding company and wholly owned subsidiary, all startups and all small companies which are private companies basically. So all are getting covered under this provision, and people should use the more and more of this provision without rather going to the NCLT where there is a lot of pressure from matters relating to insolvencies or operation mismanagement, etc., which takes a lot of time. So amalgamation and merger should be shifted. Most of the cases should be shifted to RD level because more of them are very technical in nature and it can be fast tracked. So that is a good idea, I think.
So with this, thank you very much, Madam Yogini, Manoj, and Suman, and the participants. This is just our poll which we have conducted. What do you consider the biggest challenge when executing fast track merger under 233? Regulatory compliance, shareholder approval, 51% saying, and documentation process, 26%. What are your expectations regarding time frame for completing fast track merger? Less than 3 months, 3 to 6 months. There is the highest 56%. Less than 3 months, 32%. More than 6 months, 12%. Next, what do you think are the primary benefit to pursue fast track merger compared to the conventional merger? Expedited timeline 56%, cost saving 15%, reduce regulatory hurdle 23%, enhance business agility 6%. So these are the poll which we have done during this. So with this, I just thank everyone and all my participants, and special thanks to the all person, those who have asked questions, because your questions enhance the knowledge of others as well as the speakers and panelists also, because your question sometimes is a tricky question also, so you have to understand and give. And I thank every participant, those who have come in large number. So friends, thank you all. And this knowledge sharing will continue. And our next webinar is 176, which I told in the beginning, on 14 June will be on the importance of ESG integration strategies, targeting going net zero. That will take. And we will invite the expert on this. With these things, thank you very much. See you next Friday, 4 o'clock. Thank you very much.